will be in a very, very reasonable place.
My lord, grateful, my lord. And another case, my lord, where the Honorable High Court, my lord, already recalled my 260 appeal because the order was passed and it was dismissed. It is my appeal. And after that, upon application, it has been recalled by the division bench. But in any reason, it has not been properly posted in the server. That is why it is showing that it is already disposed of. But matter has not been disposed of. So may I hand over the respective to judge one order and another order of recalling, as your lordship can be put it in the to be mentioned as a to be mentioned in the list, and after that your lordship can,
First, what we do is we have to trace the file. Because it was dismissed, probably it would have gone to the record section.
No, it has been recalled again, and file is available here because we have taken the certified copy very recently.
Then so we'll do one thing. We'll list the matter under the caption to be mentioned next week.
Yes, madam.
Or we'll keep it on Saturday. You please come.
Yes, yes, I am ready to do that Saturday even. No problem.
Next week.
Okay, grateful, madam. And এই যে নোটিশটা আছে আদার সাইড কে দিয়েছিল
Yes, any other questioning?
May I mention, my lord?
Yes, please.
My lord, one matter, my lord, we are praying for listing, my lord. It is a cross appeal by the petitioner. It is a departmental appeal. So now we have filed the cross appeal as your lordship had allowed us. My lord, it may be listed, my lord. We had prayed for listing in the, my lord, the memo on Tuesday, last Tuesday which went by. So if any date, my lord, next Monday or
next week Tuesday we will list it.
Yes, my lord.
Please give the number. Ask your junior to give the number.
Yes, yes, my junior will give the number. Grateful, man.
Yes. Yes, Mr. Majmundar, what do you want?
My lord, may I be permitted to mention, my lord, one matter?
Yes.
It's a service tax matter relating to pre-deposit. Actually, previously there was a system to apply before the authority for determination of the quantum of pre-deposit. They have applied, and on being aggrieved against the determination, they came before the single bench. Thereafter, before the division bench, where the quantum was kept intact, but the time limit was extended for deposit the pre-deposit. And they failed to deposit within the time, but thereafter later on they deposited. They deposited now only to consider the deposit and allow the petitioner to have the pre-deposit as paid for continue with the appeal matter.
All right.
So for inclusion in the list, my lord, I am mentioning.
Who will appear for the department?
My lord?
Who appeared for the department?
Actually, I am not aware of the appearance of the department. CGST authority.
Mention a matter, you should have the case file with you. No. You should first serve a letter on the concerned advocate and then hand over to the
I have served the letter for the mentioning, my lord.
No, mentioning you have served. You tell that mentioning has been allowed and the matter will be listed under the caption to be mentioned next week, and you serve the concerned advocate. Whoever.
My lord. I will serve.
My lord, may I be permitted to mention one matter, my lord?
Yes.
My lord, it's a fresh contempt application, my lord. The order was passed by your lordships, my lord. This honorable court, my lord. Let it be listed before your lordships, my lord.
No, along with the Justice Chatterjee or along with Justice?
Yes, my lord. Yes, my lord. Along with Honorable Justice Das, my lord.
All right. You please give the number. We'll list.
Grateful, my lord.
Original side daily list item number 1 for judgment.
My lord, I beg to appear, my lord, online, my lord.
Yes. We are also online. The appeal filed by the revenue is allowed and the substantial questions of law are answered in favor of the revenue.
Deeply obliged, my lord, deeply obliged.
Honestly, what we have done is, the first judgment was authored by Justice Chatterjee Das. And I have recorded my concurring opinion with her ladyship. So I don't know whether recent past Calcutta High Court such division bench order was passed, where two judges in the bench record separate judgments but agree with each other. You go through it. We'll probably it will take 1 or 2 days to be uploaded because some corrections are.
Deeply obliged, Lord. Deeply obliged.
Item number 2.
Lord, I'm appearing in this case, item number 2, my lord. Your Lordship, but here the tax effect, my lord, is less than the prescribed limit subject to, my lord. Your Lordship, I've also emailed a computation, Your Lordship. It's come from my junior's email, Shruti Datta. It's 98 lakhs, but even what has been admitted by the department, Your Lordship, is below 2 crores. Yes.
All right. You record that submission. We have heard so and so. As the tax effect involved in this appeal is less than the threshold limit mentioned in the circular issued by the central board, the revenue cannot pursue the appeal any further. Accordingly, the appeal stands disposed of on the ground of low tax effect. Substantial questions of law suggested are left open.
Grateful, my lord. I'm grateful, my lord.
The first paragraph, you please put that usual paragraph, no? This appeal has been filed under section 260A. From the memo of appeal, you can please.
But paper book has been filed, my lord. Admitted, my lord. Paper book has also been filed.
No, we are telling the AR code so that they will be able to, first paragraph they'll add.
Yes.
Then
grateful, my lord. Grateful. I'm grateful, Your Lordship.
Item number 2. Item number 3.
My lord, I am appearing in this matter, my lord. This is below tax effect.
All right. Same order as item 3, disposed of on the ground of low tax effect.
I'm grateful, my lord.
Yes.
Item number 4.
My lord, may I be permitted to appear online? About the appellant assessee, my lord.
I am for the respondent.
My lord, in this case, 2 additions were made, my lord. First of all, my lord, one disallowance of my purchase. Disallowance of purchase was purely made on the ground that the bill raised by the supplier on 14th March 1997.
1 second.
My lord, my financial year is 97-98.
You open this. This is the item. Let me get the file once. This is over. And that is item 2. This is item 3, 35. 2. No, don't. Take ITA 19 of 2011. With this place.
My lord, may I start? My lord, may I start?
Yes, please.
My lord, in this case, my lord, disallowance of my purchase was made on the ground that my bill was dated 14th March 1997. I recorded it in the books of 1st April 1997. Means, my lord, the financial year has been changed. Because, my lord, I received the goods on 1st April, I recorded in my books. And, my lord, my purchase registers, stock registers, all are there, my lord. Wherein, my lord, it is reflected that my purchase is booked on 1st April 1997. Assessing officer disallowed the same only on the ground that this is purchase for other financial year for 96-97, not for financial year 97-98, my lord. This is, my lord, first ground of disallowance, my lord. My first disallowance. My lord, kindly come to my lord, assessment order, my lord. My lord, assessment order starting from page 21, my lord. Page 21, my lord, the printed page number, my lord. Kindly consider printed page number. Page 21, sorry, my lord, this is page 24. Starting from page 24, and now the relevant paragraph is, my lord, at page 25, my lord. My lord, third line. My lord, may I read?
Yes, yes.
Sri Sheikh, page number 25, third line. Sri Sheikh produced copy of the bill number 64 belonging to Sri Dinu Ram, and along with a copy of road challan of such and such transport agency and copy of Form 40 of West Bengal sale tax. From these documents, it was seen that the bill was raised on 14th March 97, that is, during the financial year 96-97. The entire lot of weighing such and such was handed over to the transporter on 14 March 1997 for sending it to Sadab Enterprise. This is the minor document. The consignment as per Form 40 crossed could be on 28 March 1997. No evidence could be produced to prove that the consignment was received by the assessee after March 1997. This was the, my lord, assessing officer's observation.
No, you please come to page 10, the tribunal's order, page 10.
Tribunal's order, my lord.
Tribunal, page 10.
My lord. Paragraph 16.
Paragraph 16.
My lord, paragraph 16, yes, my lord.
About 10 lines from the top, the sentence starting before us. Even the copies of the relevant documents have not been furnished. The assessee has been given ample opportunity to show that in fact it had purchased goods from Dean Ram Chug so-and-so on the financial year 97-98. Nothing other than one bill number 64 was produced before the assessing officer. Before us, even that has not been furnished by the assessee. Thus, we are constrained to hold assessee had not been able to prima facie show that the impugned purchases was in fact made from so-and-so during the relevant previous year. As the assessee has not been able to discharge the onus on prima facie proving the impugned purchase, we hold that the AO was justified and impugned addition, and the Commission of Income Tax was correct in upholding. Where is the question of law, sir? There is no question of
my lord, without considering my purchase register, stock register, my sundry creditors list also are audited, my lord.
See, these are all, no. We can decide if there is a substantial question of law is concerned.
Relevant portion of this registers, my lord, is annexed in paper book, my lord, also. In this paper book, my lord. My lord, kindly come to page number 81, that is my purchase register, my lord. Relevant page of the purchase register. My lord, at page number, my lord, 82, relevant page of stock register of this paper book, my lord. Without considering these documents, my lord, they have, my lord, some observation, my lord. In fact, my lord, assessing authority and appellate. In fact, my lord, assessing authority and appellate authority both have held that I have produced the bills and Form 40 of West Bengal Sale Tax. And my lord, stock register and purchase register is annexed here. Relevant to this one in this paper book, my lord.
Sir, page 81 purchase register. Where do you get the date that it was during the financial year 97-98?
My lord, page number 81, my lord. Page number 81, my lord. My lord, first, second, third entry, my lord. My lord, date is not there, my lord. 497, Dinu, my lord. Actually, my lord, 1497, my lord. Dinu, my lord. Bill number 64.
No, it says 14th March 97.
My lord.
Bill number 64 is dated 14th March 97. But bill number 11 is dated 2nd of May 97.
Extreme left side, my lord. Extreme left, my lord. Receipt date. Extreme left, my lord.
Oh, it is 497.
Yes. It is actually 1/4/97, but while copying probably the date has been malad here. Because malad,
Sir, your voice is echoing, sir. I don't know whether you're speaking through the mobile phone or where is the assessment order?
my lord, assessment order is, my lord, at starting from page 21.
21.
Page 21. 21.
No, 21 is something else. Sir, we are having the paper book. Page 61, 64 is the assessment order, correct?
No, page 24, my lord, sorry, page 24. Printed page, my lord, printed page number. Page 24.
Yes, sir. Same thing is page 64 also.
Yes, that may be repeated, my lord, yes.
Printed.
Next page, my lord.
Page 21, as you have said.
Page 24, my lord. Printed page 24. Printed page 24 and the relevant portion is at page 25.
Sir, you come to page 25. With this on 15/1/2001, during the course of hearing, Sri Sheikh was appraised about this fact. On the next date of hearing, that is on so-and-so, Sheikh produced copy of bill number 64 belonging to Dinu Ra, along with the copy of road challan of Sahili Transport and Form 40 of the West Bengal sales tax. From these documents, it was seen that the bill was raised on 14/3/1997 during the financial year 96-97. The entire lot of goat skin weighing 4 tons was handed over to the transporter on 14/3 for sending to Sadap Enterprises, Calcutta. The consignment as per Form 40 crossed Cooch Behar on 28/3/1997. No evidence could be produced to prove that the consignment was received by the assessee after March 1997. Therefore, the total purchases related to the financial year 96-97, assessment year 97-98. Sir, no question of law. Please take down. This appeal by the assessee filed under section 260 capital A of the Income Tax Act 1961. We have heard his is directed against the order dated 30th June 2010, passed with the Income Tax Appellate Tribunal B Bench Kolkata within bracket Tribunal in ITA number 114/KOL/2010 for the assessment year 1998-99. The assessee has raised the following questions of law for consideration. Page 84, question A and B. We have heard so. On a bare perusal of the questions which have been suggested, which have been framed, it is evidently clear that the matter is entirely factual. The endeavor of the appellant before this court is to demonstrate that the purchases effected from one Inura was during the financial year 1997-98, relevant to the assessment year 1999-2000. This, according to the learned advocate appearing for the appellant assessee, the assessing officer did not examine the purchase register and erroneously held that the purchases related to the financial year 1996-97, relevant to the assessment year 1997-98, 98. No, please take out that. That sentence. Before the assessing officer, the assessee was granted an opportunity to establish their case. The assessee appeared on 1/2/2001 before the assessing officer and produced bill number 64, along with copy of the road challan of Mrs. Saili Transport Agency and form number 40 of the West Bengal sales tax. The assessing officer examined these documents and it was seen that The bill was raised on 14/3/1997, that is during the financial year 96/97, and the entire lot of goat skin weighing 4 tons was handed over to the transporter on 14/3/1997 for sending it to Sadab Enterprises, Kolkata. Full stop. The consignment, as per form number 40, crossed Kuch Bihar on 28/3/1997. Therefore, the assessing officer concluded that there is no evidence produced by the assessee to prove that the consignment was received by the assessee after March 1997. Therefore, the assessing officer held that the total purchase of rupees 6,35,360 related to the financial year 1996-97, that is the assessment year 1997-98. And under the such circumstances, the same was disallowed, as it is unrelated to the financial year 97-98, relevant to the assessment year 98-99. When the matter was carried on appeal before the appellate authority examined the factual aspects, re-examined the factual aspects, and affirmed the view taken by the assessing officer. The assessee challenged the said order by filing an appeal before the learned tribunal. The learned tribunal has once again re-examined the factual position and pointed out that nothing other than one bill number 64 was produced before the assessing officer, and before the tribunal, the assessee did not produce any other documents, to discharge the onus of prima facie proving the impugned purchase. Thus, we find there is no question of law, much less substantial question of law, arising for consideration in this appeal. Accordingly, the appeal fails. Sorry, sir. Next.
Miller, I am for the respondent.
Yes.
Lord, item number 5, my lord, I am appearing for the appellant.
My lord, I am appearing in this matter, my lord. My lord, this matter requires for consideration if we, my lord, appear physically before lordship, because this is, my lord, a block assessment, and my lord, addition was made under, and the assessment was done under 148 BD. So, my lord,
please give me 1 minute.
My lord, my lord.
No.
Sorry, sir. Sorry. You
Yes,
want to argue the matter physically?
Yes, my lord, because so many things, my lord, is required to be shown to your lordship.
But there is only one question of law admitted.
Yes, only one question. Yes.
Because, my lord, the other questions, my lord, which has been, my lord, argued by, my lord, the assessee before, my lord, the tribunal, my lord, had all went in favor of the revenue.
So whether the tribunal committed substantial error of law in rejecting the block assessment order and deleting the addition regarding the department's finding and evidence on record produced before the tribunal as well as before the lower authorities.
Yes, my lord. Because, my lord, initially, my lord, when, my lord, the notices were issued under 148 BD, my lord, those has been assailed by filing a writ petition. Then, my lord, the single bench, my lord, had held the issues in favor of the revenue. My lord, the assailing that, my lord, order, my lord, the assessee, my lord, has, my lord, challenged that order before, my lord, the honorable division bench, and division bench was concurrent in finding with the single bench. Then, my lord, an SLP has been, my lord, taken out, assailing that order regarding, my lord, the validity of the notices, my lord, that SLP
All
was.
right, then we'll have it next week, subject to Telkan's senior advocate.
My lords, the assessee has filed a cross objection with the leave of the court, which is a part of the paper book on the jurisdictional question. Right? So that is also before my lords as such. Now, there are decisions which are now available, my lord, which will help the assessee on that point as well.
Okay. So the cross objection is also here.
Yes, my lord, page 5, if my lords are pleased to see.
Yes, yes.
Okay. At the request of, we have heard so and so, at the request of the learned advocate, appealing for the appellant department, list next week.
I'm grateful.
I'm grateful.
Item number 6.
I'm appearing for the appellant. But there are two appeals. One is against the, this arises out of the fringe benefit tax.
Pardon, sir?
The fringe benefit tax.
Fringe benefit tax.
It was introduced by the Finance Act 2005 from the assessment year 2006-7. And then it was discontinued from the assessment year 2010-11. So so one appeal is not against the order of the tribunal. In the quantum matter, the order of the Commissioner of Appeals was upheld. And the other is against the order under section 263. So I have prepared a list of dates since so that there's clarity that list of dates I have mailed, and there's a compendium of the statute which has also been.
So we'll take it up next week. If you can hand over that compendium so that Mr. Mitro and Procedural can go through it.
I've handed over the compendium already to Mr. Dudoria.
Okay.
And the decisions also I will give to him.
Okay.
Item number 8 to 12.
We have heard so. One second. We have heard so and so. The learned advocate appealing for the appellant is case law and a compilation of case laws, which copies of which have been handed over to the learned advocate for the respondent department. List the matter after 2 weeks. Yes, item 8 to 12.
Item 8 to 12.
My lord, for item number 8 to 12, I will be appearing for the appellants. I'm being led by Mrs. Murarka, my lord. I'm praying for 2 weeks time, my lord. The reason being, my lord, for item number 8, the appellant Srimati Bimala Devi Poddar died on 14th May. We are in process of filing the substitution application. My lord, 2 weeks time be granted because these are analogous matters. This has to be heard together, my lord.
And in all the matters, only in item 8, she is the appellant. The
Yes, my
others,
rest of the appellants are there, my lord, but these are analogous matters, my lord. It has to be heard together.
it's a common order, is it? Tribunal's order?
Yes, my lord.
Yes, yes, it's a common order.
The courts also, this batch of appeals, in the batch of appeals, the assessees have challenged the common order passed by the tribunal. Full stop. It is submitted by the learned advocate for the appellant assessee that the appellant in ITA number 76 of 2012 is no more, and her legal has to be brought on record, for which substitution application will be filed shortly. Let the matter appear after 3 weeks. By then, appropriate application for substitution of the deceased appellant be carried out.
Deeply
My
obliged.
side, along with Mr. Soman Bhattacharya will be representing revenue in this matter.
Yes,
We are appearing.
Tilak Mitra and Soman Bhattacharya.
Item number 13.
I'm getting.
But I'm appearing for the assessor in this matter.
But I am for the Miller respondent.
But the appeal was admitted on 9th of October 2015. But on a single question, whether this particular amount was a mere provision, or was it written off as a bad debt?
This Micromax you have relied on, I think they carried the matter on appeal to the Supreme Court.
Lordship.
I think it's a decision of the division bench presided by Justice Rajiv Shaddar.
Lordship.
Correct?
Yes, maybe. I'll just check.
Micromax 277 ITR. 40.
277, I said 409.
Then
277 ITR.
Lord, I have mailed the order of Microsoft system to 5 ITR 148 taxman. In my mail, I have sent to your lordship court mail to the judge, say judgment Microsoft system. It is in favor of the revenues. But from my mail, I have sent to your lordship court the mail. Somen Bhattacharya.
You please tell the court officer, he will open it.
Mailta khulta bujhei na. Somen Bhattacharya.
But is it not covered by Vijaya Bank decision?
In my humble submission, it is because the way the accounts are presented in this assessee's case, that presentation, according to the ratio of Vijaya Bank's case, it amounts to a write-off. The 3 documents which are annexed to the petition, I'll place before my lords to show that it's actually amount was written off.
This is marked in the effect.
This new provision. You mean paragraph number 5 of is in the judgment mill, or the facts has been stated.
But the assessee's explanation, which is actually noted by the tribunal in para 5.
Yes, para 5, the last 5 lines. In the alternative, it was pointed out by the assessing officer that though the assessee had checks in the hand from Messrs. Unique Agency outstanding at the end of the year with this party, was claimed as bad debt written off by transfer of the reserve account. The proprietor of said Messrs. Unique Agency has stated on oath that no amounts were outstanding for payment. It is very much disturbing.
And what is the factual explanation, sir?
If my lords are pleased to have the profit and loss account, but at page 18, but on the expenditure side, The first is not the manufacturing account, then below that not the bottom half not the
bad debts written off.
Written off. No, this is the amount 8,97,676.72. So no, this in the profit and loss account it was reflected at bad debts written off. But then kindly have not page 25.
Yes.
But this account is titled no doubt not reserved for bad debts, but kindly see not the headings party name, opening balance, and bad debts written off during the year. So this 8,97,000 is not added to this reserve for bad debts, but the heading is bad debts written off. So the closing balance is 1,38 odd, and this has come in the balance sheet. Kindly have a look at page 17. But under the current assets, loans, and advances, sundry debtors, and less reserve for bad debts, 1,38. So this, what has happened is it is written off as bad debt, then it is posted in the reserve account, then reserve account again goes to reduce the debtors. So therefore the debtors get completely neutralized, written off in the profit and loss account as a bad debt, taken to that account, that account then neutralizes the debts to that extent. So this accounting in Vijaya Bank's case, it has been held that it amounts to a write-off, because in Vijaya Bank's case also the amount was reduced from the debtors in the balance sheet which was presented. If my lords are pleased to see Vijaya Bank's decision, it is attached to a mail which was sent this morning. OD 13 I recommend.
No, sorry, sir. So, please once again come back, because the assessing officer at page 22 he says entry passed in the books is bad debt account, was debited as bad debt, and reserve account was credited.
Yes, sir. I have shown.
Thus, a bad debt of 897, which has been written off and claimed as deduction, has not been written off in reality, but transferred to reserve for bad debt account. That is his reason.
Well, I have presented those two pages to my lords. That is what has happened. It is in the profit and loss account, page 18, it is bad debt written off. This is the precise amount. Now, this is page 25, it is that account titled reserve for bad debts. I'm not there. There is an opening balance of 1,29, and then the next column at page 25 is bad debts written off during the year. So even in that,
though the title says reserve for bad debts as on 31/3.
Lordship. So this amount bad debts written off is added to this reserve, and then in the balance sheet at page 17, this total of this at page 25 is 1,38. In the balance sheet at page 17, this entire 1,38 is reduced from the debtors.
So this has been written off, added to the closing balance. That is shown as reserve for bad debts.
Yes, and that reserve, entire amount of reserve, and the claim is only for 8,97,000. The claim is not for the rest.
So this whatever is written off has been added in the closing balance.
Yes, to the reserve balance, and then that reserve has gone to reduce the debtors note.
Where are your grounds before the Commissioner appeals?
Yes, Commissioner appeals my lords will find at page 83, 83, 84. They've all said the same thing, that does not amount to a write-off.
But they didn't compare this above the what is it? The entries in the profit and loss account along with the balance sheet. Probably they went only by the balance sheet.
They went, yes, they went by the balance sheet. They didn't look at the profit and loss account, because here, unlike in Micromax case, there it was a provision in the the profit and loss account showed a provision, but here, it is written off, taken to that account, and that account then reduces the debtors.
And what does Vijaya Bank say?
But kindly have a look at Vijaya Bank. It is attached to the mail.
No, I think one hard copy is here.
Lordship, that's a very kindly see the
it's in the sheet book.
But paragraph 2 at page 168.
All right. Then we'll do one thing, sir. Next week we'll take it physically. So it will be easier.
My lord.
All right. We have heard so and so. For continuation of arguments, this next week.
Item number 14.
Deeply obliged.
Sir. My lord, I'm appearing for the respondents, my lord.
Today, Senior Advocate Mr. Obrotosh Mojumdar is appearing in this matter. He's engaged in court number 37, Your Lordship.
All right. Not today.
Not. Next matter also, my lord.
Not today.
Item number 16.
16.
May it please, my lord. I'm appearing for the respondent, my lord.
My lord, I'm for the appellant. My lord, this matter had directed the respondents to file a compilation.
Where is the compilation?
My lord, the reasons to believe was directed to be supplied, my lord. We have mailed, my lord, in today's mail.
I have got an WhatsApp message, my lord.
No, you, Mr. Bagaria, please give a hard copy to Mr. Amit Sharma.
My lord, just one paragraph reasons, my lord.
You just take a photocopy and give it.
Item number 16.
Yes. Actually, we said the learned advocate for appearing for the respondent assessee is directed to file a compilation containing the reasons for reopening, the reply/objection submitted by the assessee, and the order passed by the AO under section 148. The grounds of appeal filed before the Commission of Income Tax Appeals, as well as the grounds of appeal filed before the learned tribunal.
My lord, the grounds are there in the petition itself, my lord. My lord, the reasons have just come up in my lord's screen, my lord. We'll see from those reasons, my lord, it is just cut, copy, paste of the DDIT, and that has been the basis of the tribunal's decision, my lord. My lord, let's go to the page number 2. Yes, my lord. No, this is the reasons, my lord.
He should have, Mr. Sharma, he should have made some verification. No?
My lord, when the case was reopened, my lord, the reasons were provided.
No,
the assessee asked.
No, it's not. I have received information from the DDIT.
My lord.
You can do the reopening. You cause a verification.
My
and
lord.
In fact, you argued another matter, no? Where the assessing officer gave the reasons to him, then issued show cause notices, asked the assessee to explain.
My lord.
So there are, in that show cause notice, he has made his application of mind, and he has, according to your argument, he has put the assessee on notice. But here, what is the reasons it says? Only one paragraph. In view of the above discussion, what discussion? At best, what he should have done is, he should have furnished this. I have received this information. Please show cause as to why further action should not be taken in this report. You submit some details and documents. After which he can record his satisfaction and communicate the reasons.
My lord, here these are the reasons, and the notice is a part of this brief, my lord, Annexure A, at page 12.
And has the assessee been named in this DDIT letter? No.
My lord, just a moment, my lord.
Krishna Nirman Private Limited has not been named in the recent.
No, my lord. No, my lord.
Please come. This
I
appeal,
am appealing in this matter.
this appeal filed by the Revenue under Section 260 Capital A of the Income Tax Act 1961, within bracket the Act, is directed against the order dated August 27, 2024, passed by the Income Tax Appellate Tribunal, C Bench, Calcutta, within bracket Tribunal, in ITA number 155/KOL/2023 for the assessment year 2009. The Revenue has raised the following substantial questions of law for consideration. Page number 6 of the state petition.
My lord, one submission may I make, my lord? Only one submission, my lord, I will make. If my lord, I'm not troubling, my lord, just my lord.
You make a submission. You are entitled to.
My lord, here after reasons were provided, my lord, the case was reopened, notice was issued. The assessee did not raise any objection. In fact, assessee participated in the proceedings, my lord. After issuance of notice under section 142(1) and 143(2),
Sir, this is a question of law which can be raised at any point of time.
My lord, I agree, my lord. But my lord, the assessee allowed the proceedings to continue. If the assessee was aggrieved, my lord, he could have challenged that reopening at the very first instance before the writ court. Did not challenge. In the assessment proceedings, my lord, the assessee participated fully. Submitted documents. On the basis of, my lord, those findings, the assessing officer came to conclusion. Had the, my lord, the original assessment was under section 143(1). Here, my lord, the assessee is unable to show that he has raised any objection.
Lord, at page 17, the grounds before Commissioner Appeals are there. The first
before the assessing officer.
The first ground itself is regarding 147.
My lord,
page 17, my lord, will kindly see ground 1, para 4.
That is before the appellate authority, before the assessing officer, my lord.
And even before the tribunal, the ground was raised.
He did not object.
But in the assessment order, Mr. Sharma, there is no reference to the information provided by the investigation, except in the first paragraph.
My lord. But in the assessment order, there is no reference, my lord.
About?
But in the assessment order, my lord, there is no reference, my lord. We had participated.
Yes, my lord. My lord, kindly
my
see.
lord, before the Commissioner Appeals and before the tribunal.
Page 13, my lord. Page 13, last paragraph. For verification of such transaction of shares to the above companies, notices under section 143(6) and summons 143 were issued.
No, please hear.
My lord.
Paragraph of the assessment order at page 13. No doubt there is a reference to the DDIT.
My lord.
Thereafter, the assessee was issued notice under 143(2) and 141.
Yes, various details as reflected in the 148 return. last paragraph.
Thereafter, there's nothing. There is no reference to the DDIT report. So he put the cart before the horse.
No, my lord. My lord, here, my lord, the last paragraph, kindly once, my lord. The company in compliance of notice under section 133(6) of the IT Act, the transaction has duly been verified and kept on record. Against the summons under section 131 to the directors of the above companies, depositions were taken and duly placed on record. Next paragraph, my lord.
Therefore, you should link that information for the purpose of completing the reassessment. You commenced it with the report of the DDIT, letter of the DDIT. You put him on notice. He made certain submissions. Thereafter, you have abandoned the reasons for reopening and proceeded on a different footing.
Well, if your lordship, kindly take note of the date. On 27th of March 2015, the day when this 148 notice was issued, along with the recorded reasons. Now, in compliance to that notice, the return was filed on 29th of December 2015. So, in between, with regard to the materials, on the basis of which we have proposed to the reassess, there was no objections with regard to the jurisdiction that is proposed to be exercised. So, no jurisdictional objection has been raised at the first instance. If it is now the contention
before the appellate authority, they have raised.
Yes, ma'am.
Before the tribunal, they have raised.
Yes, ma'am.
Tribunal in page 29, para 8. We, after considering the facts and record, find that the AO has merely issued the reopening notice on the basis of the intimation regarding reopening notice from DDIT. This is a clear breach of the settled position of law that reopening notice has been issued on his own satisfaction, not on borrowed satisfaction. Therefore, we set aside the order. All right, please come. We also, this appeal, so substantial questions of law for consideration, page number 6, question 1 and 2 is sufficient. We have heard so and so. The short issue which falls for consideration is whether the reopening of the assessment was bad in law on account of the fact that the assessing officer did not independently apply his mind to the information provided by the investigation wing. The learned tribunal has as could be seen from the assessment order, this objection appears to have not been raised by the assessee, but nonetheless, the assessing officer, though refers to the letter information received from the investigation department, while completing the assessment under section 147 read with section 143(3), has virtually abandoned those reasons and proceeded on a different footing. Before the first appellate authority, the assessee specifically raised the issue that the notice which was issued for reopening is merely based on information from the investigation wing, and there is no incriminating evidence found against the assessee company so as to assume jurisdiction to reassess the income of the assessee. Though such a ground was canvassed, the appellate authority did not agree with the assessee and dismissed the appeal. Before the learned tribunal, the same ground was urged by the assessee. The learned tribunal carefully examined the factual position and found that the assessing officer has recorded the reasons in a belief, recorded the reasons without application of mind on the information received from the investigation wing. Apart from that, the learned tribunal also found that the reasons recorded by the assessing officer are vague, non-specific and non-essential to form the belief that income has escaped assessment. The learned tribunal took note of the decision of the High Court of Delhi in the case of PCIT versus G&G Pharma, ITA number 545 of 2015. as well as the decision in the case of PCIT versus Shodiman Investment Private Limited, 2018 93 taxman.com 153 within bracket Bombay, and allowed the assessee's appeal on the ground that that the reopening of the assessment was clearly in breach of the settled position of law. Thus, the learned tribunal has arrived at such a finding upon reappreciation of the factual position, and we find no question of law, much less substantial question of law, arising for consideration in this appeal. Accordingly, the appeal fails and it is dismissed. Tax effect is only 29 lakhs. Of
My
course,
lord.
exception
But
clause.
that is also one point, my lord. Share premium, they are just taking the benefit of the circular by saying that it comes within that exception.
Yes,
my
yes,
lord,
we decided both ways.
my lord. I'm grateful, my lord.
BST have decided against the SSC. Certain other cases, we have decided
Yes, my lord.
in favor of
So
the
that
SSC.
is why, my lord, I did not point that out, my lord.
Basically facts, sir. Basically
My
facts.
lord. Absolutely.
Next.
Grateful, my lord.
Item number 17.
17, my lord, I'm led by Mr. Dutt. He is on online, my lord.
My lords, Mr. Senior Advocate, Mr. Obrutosh Mojumdar is appearing in this matter. May I pray for not today?
Not today.
Item 18.
My lord, I am appearing. My lord, I am
item
praying
number
for
18,
not to in this matter, my lord, because
Why, Sweta, you're not ready?
my lord, I am ready, my lord. My lord, I have been instructed, my lord, the client by the petition appellant, my lord, they may appoint a senior, my lord. So, my lord, I have to only for that reason, my lord. Otherwise, I will apprise your lordship on the next.
We have heard so and so at the request of the learned advocate for the appellant assessee list next week.
I'm grateful.
Or after 2 weeks, you put. By then you.
No, my lord, next week, my lord. Otherwise, I will do this.
All right, next week. Next.
Item 19.
Lord, I'm appearing in this case, Lord. The section 68, Madam Lord. In this case, Lord, the SSC company has taken unsecured loan from Nikhil Holding. If your lordship will kindly see the assessment order first, Lord, I'm showing only 2-3 paragraphs of assessment order and then thereafter CIT's order. Lord, assessment order starts at page number 11, page number 13. If your lordship will kindly see paragraph number 2.6. The SSC company has taken unsecured loan from Nikhil Holding during the financial year under consideration. Murlidhar Lahoti, who is one of the director of Nikhil Holding Limited. He accepted the statement that the Nikhil Holding Private Limited is a shell company which is being run to provide accommodation entry through various entry operators. List of the beneficiaries were provided.
No, Mr. Doria, we'll take it up after 1 week. We have another judgment, no? Mr. Majumdar also argued, I think. Who argued?
No, Mr. Dutt is also leading me in this case.
I am leading in this matter.
But this is a very short matter, my lord, because
next week we'll take it up.
Next week, your lordship.
Item number 20.
My lord, in item number 20, my lord had directed me to take certain instructions from the department. My lord, I'm facing some difficulty, so kindly grant me 2 weeks time, my lord.
In this matter, if I may indicate, your lordship, the query was that whether Commissioner of Income Tax Appeals in the earlier year had decided the issue in favor of the assessee.
Yes.
And following that, the tribunal has granted us relief because saying that relying on the principle of consistency primarily. Your lordship, as far as appeal before the tribunal is concerned, my instructions are that no appeal has been filed before the tribunal, and I even personally checked the portal of the tribunal, your lordship. No appeal has been filed, and many years have gone by, your lordship. I don't think a department has filed any appeal at all.
Because that was for 13-14.
Yes, your lordship.
Yes, my lord, this is 34.
So there is no appeal
Whether
filed by the
the
department.
We have heard so and so.
assessment has been
All right. By order dated 21/7/2025, the learned advocate appearing for the respondent appellant department was directed to get necessary instruction from the department. The learned advocate requests for a week's time. Let the matter come up 1 day week.
Millet, in this matter also I am appearing, Millet.
Yes, sir. Arya Dutt and Amit.
I'm grateful, madam.
Item 21.
21, how many days delay, sir? No delay. Who will appear for the assessee? Who's appearing for the assessee? 50,000 rupees cost has been imposed. All right. We'll say not today. So we will stop original side with this. Switch over to appellate side.
Appellate side.
Mention. My lord, may I mention a matter, my lord?
Yes.
Lord, I crave leave to file an appeal, memorandum of appeal, my lord, without certified copy.
What is the date of the order?
18 July 2025, my lord.
Yes, leave granted.
Great privilege.
My lord, I am for the petitioner, my lord.
Let them call out once again.
These are the services. My lord,
So who will appear for the respondent? Deputy Commissioner, Commercial Taxes. Ezra Street. All right. We'll say not today.
not today.
We have heard so and so. None appears for the respondent. Let the matter appear tomorrow.
Grateful to your honor.
Next.
Item number 2.
Two also nobody is appearing.
I'm for the appellant, my lord.
You are for the appellant.
The state Tono is appearing for the respondent, my lord.
What is this? The matter was released from the tribunal, is it?
This tribunal, my lord, there is no technical member right now. The only one technical member is there, my lord. Only difficulty is that he cannot take up the matter because he appeared for the respondent in all the matters. Almost 70.
God.
Sorry, my lord.
Then what to do? We have to see what was the order which you challenged before the tribunal?
Before the tribunal, my lord, what happened, my lord? There is a amendment made in the definition of dealer. They made a retrospective amendment in the West Bengal Sales Tax Act 1994. Then subsequently we challenged before against the order passed by the tribunal. We preferred an appeal before the High Court. High Court has remanded back to the tribunal once again because there is an amendment made in the Schedule 1 to the West Bengal Taxation Tribunal Act 1987. The Sales Tax Act and VAT all has to be dealt by the Taxation Tribunal. That is why the matter was remanded back to the tribunal.
Where is that order of remand?
Kindly see page 31 and 32. Almost 17 matters pending, but the list is annexed in the petition is page number 30. Almost 12 and 31 petition has been pending before the High Tribunal, my lord. And the last order at page 31.
From my chamber, data house, when I came to the court, I have took up the traffic is registered.
No. Page 30, it says sales tax details.
Yes, my lord. These are pending before the tribunal. All the same issue is involved, my lord. Whether the definition of the dealer can be given a retrospective.
Then what?
He has filed the appeal, and his appeal is pending. He has gone to the Vivace scheme as Vivace scheme, but when for settling in the Vivace scheme, the department would not ascertain his appeal. That's why, he could not avail. I remember you. Yes. Now, I have taken.
You please say this is some old matter, sir. Wait, no, Soman Bhattacharya is saying something. Now, the technical member has appeared for which client?
Well, there is only one technical member right now in the tribunal. And he, my lord, passed the order, released the matter because of the reason he appeared for the respondent, for the department. So that he cannot take up the matter, my lord.
So what to do?
My lord, kindly give us the liberty to file a writ petition on all the matters before the High Court or. My lord, this matter is pending. They are pressurizing for the demands. My lord.
Your Lordship, kindly see PCIT 5
My lord, can
portion.
All right.
Some sounds coming from out.
Petitioner. None appears for the respondent. Next week. Now you come with a workable solution. See, the problem is we can't drag the matters before the tribunal. If the tribunal releases all the matters, then probably we can convert it into.
Can't hear you properly, my lord. Some noise is coming.
Crosstalk is there. All right. Next.
Item number 3.
Lordship, item number 3, Lordship, I am appearing for the petitioner, Lordship. Lordship, unfortunately, Lordship, I very humbly pray before you, Lordship. The internet connection is not at all stable from where I am appearing, Lordship. Lordship, just pray for an adjournment, Lordship. I will very humbly request you, Lordship, the matter appear on next Wednesday, on 6th of August.
At the request of the learned advocate for the appellant, list next Wednesday under the same caption.
I am grateful to you, Lordship.
Next.
Item number 4.
My lord, I am appearing for the petition, my lord.
My lord, before my learned senior starts the argument, my lord, Mr. Dey is appearing on behalf of the answering respondent, my lord, due to some medical emergency, my lord. See, my lord, today he has not come, my lord. If your lordship kindly take up the matter next week, my lord. They requested me to pray.
This is the third time they are seeking adjournment. Every time.
Today, my lord, there is a medical emergency.
What to do, Mr. Sharaf? Medical emergency does not come with advance notice.
Yes. I am sorry, madam.
Expect notice under 80 CPC before you get fever.
Yes. Monday, madam.
Monday. You have heard Mr. So-and-so, and advocate for the petition appellant. It is submitted that Mr. Kaushik De, learned advocate appearing for the CGHC authorities, is unable to attend court today. Hence, adjournment is sought for. List under the same caption on Monday.
Grateful, my lord.
Grateful, madam.
Item number 5.
In item number 5, my lord, I am appearing for the respondent numbers 1, 2, and 3, my lord.
Who are the other respondents?
My lord,
private respondents.
Yes.
And who appeared for them? Pro forma respondents.
My lord, on behalf of the petitioner, Mr. Ghoshal is appearing as far as my knowledge is concerned, my lord. My lord, let this matter be fixed on next week on any day. I will produce some documents also, my lord.
All right. One appears for the appellant. You have heard Mr. Amit Sharma, learned standing counsel for the respondents 1, 2, and 3. List the matter under the same caption next Thursday.
I'm grateful.
Item number 6.
Today, nobody is there for the state.
No one is there, my lord. Doesn't seem to be.
I don't know, because we were informed yesterday that Mr. Siddiqui is no longer in the panel. He has resigned.
Yes, my lord.
And probably Tanay is held up somewhere. I don't know. All right. Then let it come tomorrow or next week.
Next week, my lord.
No. When do you want it?
Any convenient day for the bench, my lord.
All right. List the matter next week. Next.
Item number 7.
7.
My lord, I appear for the petitioner. Appellant.
I'm for the respondents, my lord.
Lord, this
I'm
an application for restoration, my lord.
On what date it was dismissed?
My lord, it was dismissed on
7th of May 2025.
And what was challenged in the appeal?
Yes, my lord. My lord, if your lordship is kind enough to come to page 10 of the restoration application,
Mm-hmm.
my lord, this was an intra-court appeal,
Mm.
my lord, against a proceeding under section 148.
Mm.
My lord, what happened, my lord? This matter was admitted by the division bench on 14th of August 2018, my lord, and thereafter, my lord, if your lordship kindly comes to page 8, paragraph 8 at page 4, your lordship will very kindly find that in between, because of COVID, the matter did not come, and at paragraph 8, your lordship will find on 12th of July 2024, that Honorable Division Bench comprising of Honorable Justice Kesharwani and Honorable Justice Ajay Kumar Gupta was pleased to direct the matter to come in the monthly list of August 2024. Thereafter, my lord, the matter did not come, and at paragraph 11, your lordship will very kindly find, in view of the notification published, my lord, mandamus appeals irrespective of classification was assigned to the Honorable Division Bench comprising of Honorable Justice Mantha and Honorable Justice Ajay Kumar Gupta. My lord, we kept a close watch, my lord, but that also it did not come. Thereafter, my lord, thereafter, my lord, when we, at paragraph 13, 14, my lord, the matter also did not come. We, my lord, as far as possible, bona fidely kept a watch on the list. Then, my lord, for some time, my lord, there was some, my lord, some confusion, my lord, and ultimately, at paragraph 15, your lordship will very kindly find that when, at the instruction of the client, my lord, we decided to pursue for inclusion of the matter in the list, we, my lord, discovered.
No, Mr. Sen, there is no difficulty, we can restore. But the appeal was dismissed on 7th of May 2025.
My lord.
What happened thereafter?
My lord, initially, when the matter was dismissed, it was not within our knowledge, my lord, and definitely, my lord, we did not take any steps, my lord. Ultimately, my lord, on 15th of July, my lord, when it came to our knowledge, when we were taking steps for having the matter included in the list, my lord, on 15th of July, my lord, it came to our knowledge, my lord, and thereafter we took
We will
steps.
restore the appeal, Mr. Sen. There is no difficulty. The learned judge, Honorable Division Bench, when they admitted the appeal on 14th of August 2018,
my lord,
they said that you will participate in the reassessment proceedings. And the reassessment order, if any,
my
shall
lord,
be brought on record as a supplementary affidavit.
my lord,
What happened?
my lord, subsequently reassessment was completed, my lord, and pursuant to the kind leave given by the Honorable Division Bench, my lord, we have also kept our supplementary affidavit ready, challenging the order so passed under section 147.
Mr. Dutt and Mr. Amit Sharma will restore the appeal, and we'll hear the appeal after 2 weeks.
Yes, my lord. My lord, may I request my
lord, in the meantime, my lord, let the interim order be restored.
What interim order? There is nothing, no interim order.
My lord, if your lordship kindly comes to page 16 for once, my lord, page 10 for once, that is the order, and at page 12, my lord, your lordship will find, my lord, last but third paragraph.
You have read that, Mr. Sen. It says the assessment or reassessment proceedings against the appellant may continue, but the respondents will not enforce any demand against them till the disposal. Now, that is why we are asking, have they issued a demand?
No, till now, my lord.
Instruction is something. We will restore the appeal today. You file an application. In that application, if you have to challenge the reassessment order, you raise supplementary grounds, additional grounds. In that, you make a prayer for stay of recovery.
But pursuant to this leave so granted by the Honorable Division Bench, we have taken out a supplementary affidavit challenging the reassessment order, my lord.
Right, sir, let it come on record. It is not before us. We can't stay something in the air. We have heard so and so, so and so. This appeal was admitted by the Honorable Division Bench on 14/8/2018, and an interim order was granted to the effect that the appellant assessee shall participate in the reassessment proceedings. However, the respondent department shall not enforce any demand against them till the disposal of the appeal. the appellant, the reassessment order was permitted to be brought on record by way of a supplementary affidavit or in the paper books. The learned advocate appearing for the appellant submitted that during the pendency of the appeal, the reassessment proceedings has been completed and a reassessment order has been passed. Considering the factual position and also the explanation offered by the assessee, we are of the view that sufficient cause has been shown by the assessee for not being able to be present in court when the matter was taken up for hearing on 7/5/2025. That apart, when the appeal has been admitted as in the year 2018, we deem it appropriate to restore the appeal so that the appeal can be heard and decided on merits. Heard and decided on merits. It is seen that there is a delay in filing the application for restoration, and we find the explanation offered is satisfactory, and therefore the delay in filing the appeal is condoned. Accordingly, which is the condoned delay application? Can 3 of 2023? No, can 3 of 2025 is allowed. For the reasons stated above, the appeal stands restored to the file of this court to be heard and decided on merits, and can 2 of 2025 is allowed. The appellant is, in terms of the liberty granted in the order dated 14/8/2018, let a supplementary affidavit be filed by the appellant assessee. Along with that, liberty is also granted to pray for appropriate interim orders in the event there is any coercive action being initiated by the respondent department for recovery of the tax dues. Next, let the matter be listed.
Milord, I am again renewing my prayer. Milord. Let there be status quo, Milord.
Sorry.
Milord, Lordship, kindly consider, Milord.
We have considered and restored the appeal. Be happy. You advise your client.
Milord, at least for 2 weeks, Milord. Lordship, kindly consider, Milord.
Sorry,
at least for 2 weeks, Milord. Let there be status quo, Milord.
Sorry, sir.
Limited, Milord. I am
you
limited.
File an application, we will take up the application. List the matter as and when the application is filed. Next.
Deeply overwhelmed.
Item number 9.
Let's say
I am for the petitioner, my lord.
My lord.
On behalf of state, my lord.
40% is absolute. For 40%, my lord, construction is all. My last order, my lord, corporation and police are directed to file report, my lord.
Well, I am submitting the report today, my lord, before the losses court, my lord.
But kindly supplementary evidence,
I am submitting the report, my lord, day to day, my lord, the actions have been taken and the constraint, my lord, the position, the difficulty to speed up the work that has also been mentioned, my lord, but it is going on.
Let me have the report, my lord.
Well,
Yes.
I'll give the report.
Please take down in terms of the directions issued on 3/7/2025. The Calcutta Municipal Corporation has filed a report. Let a copy of the report be furnished to the learned advocate for the contempt applicant. Liberty is granted to file exception to the report if they so desire. List the matter up to 2 weeks.
My lord, I am appearing for the state, my lord. I am filing my compliance report on behalf of the police authority, my lord.
The report filed by the police authority is also taken on record. Let copy be served on the learned advocate for the contempt application. Liberty granted to file exception to the report if the applicant so desires. Next.
Read the report given to me.
My report had all been submitted to the given to my learned friend.
We have already said, sir, copy will be given to you. Next.
My lord, I am filing supplementary affidavit, my lord.
All right, supplementary affidavit filed by the applicant. You serve copy. Have you served copy?
My lord.
My lord, extremely sorry, my lord.
You serve copy.
My lord, I beseech your lordships, my lord, extremely sorry, my lord. Item number 5, my lord. I was before 37, my lord, where I came rushing, my lord. Item number 5 of your lordship's list, my lord. I believe lordship was pleased to, my lord. I'm sorry, my lord.
I think we are listed it tomorrow.
No, next Thursday. My learned friend is here, my lord.
All right, tomorrow.
tomorrow. Deeply obliged, my lord.
Yes,
Deeply
yes.
obliged.
Item 5 tomorrow. Instead of next Thursday, tomorrow.
I'm extremely sorry, my lord. I had to.
No
my lord.
problem. Next.
Item number 10.
Not today.
Item number 11 with 12.
Not today. Thank you.
All for tomorrow. This is all for today, my lord.